Part 2. Note, once these questions have been completed and the courts review the videotape, you can see that these officers are lying and the report is fabricated. For example, in the police report, page 2, line 10, upon contact with the sole occupant and driver of the vehicle, I observed he appeared to be very nervous. The subject identified himself as Philip Sanders and presented me a California ID. First, note, the officer that handcuffed me while in the police car, or while in the car, searched me, booked me into jail, did not write the report. Slick cops. I never identified myself to Gebhardt or gave him my ID. The video will deem the officer casually approached me first and said thank you when I gave him my ID. Listen to the videotape. This can be deemed when the courts view the tape closely. The wording of the report is off. At the beginning of the report, it seems like Gebhardt approached me first. His report states word for word, upon contact with the sole occupant and driver, I observed that he appeared to be nervous. The subject identified him as Philip Sanders and presented me with a California ID. But in the next paragraph, the report states, Kazarin ordered me out of the vehicle. Very odd, because they're lying. Not to mention, the report admits to locking me in the back of the police car before finding any drugs or testing me for being under the influence. They ran no field test on me or any drugs. Why not? If I was sweating profusely like the report said, they should have ran a test. They're lying. I was eating the food wrappers between my legs. If you freeze frame the video, you could see that. Nevertheless, page 3 of the report, line 17 states Sanders stated I wanted to exercise my Fifth Amendment right. Thus, motion to suppress. Plus more, what attorney would let any alleged dope be placed into evidence when no field test was ran, plus no drug was booked into the police evidence locker in my presence, and the drug result test superseded the bail bond date? Smells like a Mark Furman in the OJ case. They think I'm that dumb. I know case law that would deem this case is going nowhere. In the case of Joe Wiley versus the state of California, Joe Wiley had rock cocaine in his pocket. Got stopped about 3 in the morning off Parkway Drive around March of 2009. Remind that Joe had 2 strikes for stealing off carports and trumped up 2 strikes back in the 80s. Not a bad guy. He took care of retired Judge Franson, the late retired Judge Franson. Nevertheless, Joe had dope in his pocket. The DA had him sweating for 2 or 3 months. But given the time for the crime, 25 years to life, the public defender showed some heart and pulled out the right case law. His public defender told the courts Joe was not on probation or parole, neither was I, and the officer had no right to go into his pockets. He was only subject to an exterior pat-down for weapons. Motion to suppress, case dismissed. Oddly, I met Joe while in jail in 2009 when I was arrested at the federal courthouse in Judge Wanger's court by U.S. Marshals for an alleged probation violation 2 years past my max probation date. The DA and the probation had to use manipulated and fabricated probation reports just to hold me. The case was so old, my attorneys didn't even have the file in court and still suggested a plea deal. I had to do 1 year behind their legal malpractice. Judge Whitehead and the DA claimed immunity. Federal Judge Wanger retired, so I sued the dump truck attorney. See case 11 CE SC 024628, Philip Sanders versus David Muggeridge. It's nothing short of an insult for a judge, DA, and a court-appointed attorney to suggest a plea deal for an innocent person. It's kind of Hitlerish. I feel if Joe did not have a relationship with the late Judge Franson, the DA and the attorneys would have treated him like a dumb nigga fresh off the slave boat, just like they're doing me. Federal Superior Court commissioner, judges, DAs, and attorneys treat black men like they're dumb and fresh off the slave boat. For example, the police feel that they can put anything down on the police report and get away with it. When they play golf with friends in the DA's office, that's the oldest trick in the book. For example, again, how can the police put on the police report, I raped Miss Obama when she was out of the country. Then when I get to court, the judge, the DA, and the dump truck attorney suggest a plea deal, saying, if you take anger management, we will drop the case. While laughing in the back room, you think the dumb nigga will take the deal? Insultingly reckless. They think I'm that dumb. More case law. Motion to suppress because of case law. Case 1, Florida versus Wells, states an inventory search must not be the reuse of a general rummaging in order to discover incriminating evidence. Case 2, Colorado versus Berlin. Impound discretion should not be exercised to investigate suspicious criminal activity. Having said that, in the order striking my amended complaint, the court ordered plaintiff to my next status report due on January 25th, 2012. Accordingly, plaintiff was ordered to file the status report before this date, properly captioned and so on, and advise the court where we are in the criminal proceeding. With that, the court left me no room to correct the errors when the court said the report shall contain no other information. So they left me no other choice but to address the lead Judge O'Neill to intercede and correct the records. As to the present status of the criminal case today, I had to file a complaint with the grand jury, the Commission of Judicial Performance, President Obama, Governor Brown, and the Department of Justice